So once again, good morning, everyone. Welcome to the last session of SAPIENS scientific webinar series. Today we'll be focusing on sustainability clauses in public and private contracting, especially in the aftermath of corporate sustainability due diligence, which is published finally in the official journal last week. So this makes our topic more maybe noteworthy or exciting, at least for me it is. So I just briefly introduce myself and then give the floor to other presenters to briefly introduce themselves. Then we can start with Katerina's presentation. I'm Ezgi. I'm a third year PhD student at the University of Turin, also an early stage researcher at SAPIENS Network. SAPIENS Network is a Europe Horizon 2020 funded project focusing on sustainable public procurement. We have 15 PhD students researching sustainable public procurement from different perspectives. And my individual research focuses on the interplay between public procurement and contract law, as well as corporate sustainability. So overall, today's discussion is my research focus, basically. So you can go ahead, Katerina.
Wonderful. Hello, everybody. Good morning. Thank you, Ezgi, for having me here and for doing this webinar with this, for me, also exciting topic. I come from the contract law perspective. I'm associate professor of law at Aarhus University in Denmark. I'm teaching mostly in environmental law, but my background is in contract law. So I connect these two areas in my research currently. Ezgi, will you share my presentation?
Yes. So maybe let's give the other presenters to like a brief introduction, if they can. Yes. Daniel, if you want to go first.
Yeah, with pleasure. I'm a German lawyer specialized on business and human rights, and I'm lead European legal advisor for the Responsible Contracting Project. And yeah, in other functions, I work in-house as a lawyer implementing the German Supply Chain Due Diligence Act and also with German firms implementing this act. And yeah, thanks a lot for the invitation to this very interesting discussion that is very, very relevant. Thank you. Giving over to Martijn.
Yes.
Thank you, Daniel. Indeed, my name is Martijn Scheltema. I'm also very happy to be in this very interesting webinar. And thank you for having me. I'm a practicing lawyer in the Netherlands, in The Hague, partner at the law firm and head of our business human rights practice. We do a lot of procurement work as well, for especially governments. I'm a professor at Erasmus University in Rotterdam, part-time, also working on this issue, and have some other relevant international functions in this field. But specifically, and that's a project where Daniel is also involved in, I'm the co-chair of the working group on European model clauses, which try to develop model clauses for supply chains, which are aligned with, of course, the OECD guidelines, UNGPs, but also with the CSDDD. And well, on the verge of starting a consultation of the zero draft of these clauses. And so that will probably be, the coming weeks, we'll start this consultation. So those of you who are interested in that, and that will be also on the website of the Responsible Contracting Project. So those of you interested in that, please, engage in the consultation. Thank you.
Okay, so now I'll share slides. Can everyone see it?
Yes,
Okay, great.
Wonderful. So I will be the first one speaking today about sustainability contractual clauses. And this being said, that means that maybe in some of the things I will say, I will be quite basic as I'm setting the scene for today. So Ezgi, please, second slide. And you can just put everything what is on the slide. Just click until this, I will tell you. Yes, yes, thank you. So it has become a common practice for companies to include some sustainability contractual clauses in their supply chain agreements and other business contracts as well. But supply chain agreements are kind of the typical example of this development. And what are sustainability contractual clauses? Now here, it might be a little bit different between the private and public law perspective, because I have a definition, my working definition, which says that sustainability contractual clauses are clauses covering social and environmental obligations that are not directly related to the subject matter. And here I think I'm diverting from the public law. They also pursue long-term business interests and public interests rather than transaction-specific private interest of the contractual parties. And they also are primarily enforced through relational monitoring and enforcement tools rather than going to the court and enforcing such clauses or compliance with them through courts. Now, these clauses, I say, became a common practice among companies, but how common? It is a bit difficult to, I'm sorry, I have a very loud airplane above me. It's kind of scary in these times. So how common it is really? It is quite difficult to figure out because business contracts are usually confidential documents of companies. So what do we do or what do researchers do? They look on reporting of companies about these clauses. In 2007, Professor Vandenberg from the Vanderbilt University in the US, he, in his seminal article, which was called The New Walmart Effect, he figured out or found out that about 50% already at the time of companies he investigated, large companies, include some environmental clauses in their contracts. I have repeated the study in 2016, so it's already also quite old study. And at the time, I found out that this number increased to over 80%, that companies included some type of environmental clause in their business contracts. Now, when we look into labor and human rights, we have made a similar study that compared the situation in 2012 and 2017, and we see such an increase as well of about 20% among between those years. And that corresponds quite nicely with the latest report of EcoVadis that studies large companies in the basically globally, mostly in the EU and US, but globally. And they figured out in 2018 that about 73% of the studied companies, and they have much larger sample than I was able to do. So they figured out that about 3/4 of companies include some sustainability clause in their contract. Ezgi, will you please go to the next slide? Thank you. So why do companies actually engage with sustainability in their contracts? Why do they include sustainability contractual clauses in their business contracts? You could say, nowadays it's changing, but you could say that in past companies were here to make profit mostly. But the purpose of companies has been kind of reformulated, not so much in law. We actually do not find anywhere in many of jurisdictions, we don't find anywhere the obligations for companies to make profit and nothing else than profit. So why do they engage with sustainability contractual clauses? Well, first, it was risk management. First, it was basically that companies were afraid that they will be disclosed as non-ethical companies, and that it will have some repercussions in respect to reputation and economy as well. Recently, or I could say the last 10-15 years, a new motivation kind of play into this, and that's consumers' interest into sustainable products, and also interest of financiers into sustainability. So companies will not get investment so easily if they don't show that they care about environment and labor and human rights and other sustainability issues. And the last motivation that is very topical right now is that there is increasing legalization of this area. So we see more and more regulation trying to impose on companies the obligation to use their contracts for sustainability purposes. So the regulation is moving slowly but steadily from soft to hard, from voluntary to mandatory regulation. The CSDDD is the latest example of this development, which will establish obligation for the largest companies, only the very largest companies, to use their contracting for sustainability purposes. But of course, our today's other speakers will go into detail with this obligation, so I will not go into detail with this. Ezgi, please. Yes, thank you. And one more click. Yes. So sustainability contractual clauses are basically used as a type of regulation. And that's because we have this regulatory gap. International law doesn't capture international supply chains. National law doesn't capture them either because it's applied only nationally. So we need to search for other tools, to use other legal tools to use to regulate international supply chains in respect to sustainability. And here contracts come into play. Sustainability contractual clauses have been used for a long time now. We saw already 2007, 50% of companies using some environmental clauses. So it's not a new development. But during the history of their use, they have been criticized quite heavily for many different reasons, and mostly for low effectiveness, for just contributing to companies' window dressing, and simply not having a real impact. So here it might be interesting to look on some theories about transnational regulation. And I use this model by Getz to see that if we tune somehow the sustainability contractual clauses, we can increase their effectiveness and we can increase their effect. So, Ezgi, the next slide, please. The first attribute that we can tune is basically to make it clear that these commitments, sustainability commitments, are binding part of the contract. So it should be like a clear that it is a contractual commitment between the parties. Now, as you see on the slide, I say, are SECs a binding part of a contract? And then I scratch it down and I say, well, are they perceived as binding part of contracts? That's because it would be quite hard to enforce those clauses through courts, actually, through national contract law. So the perception of binding power of those clauses is very important here. Contractual sustainability contractual clauses are incorporated in contracts either as express terms or they are incorporated by reference to another document. That can be a corporate code of conduct. It can be, for example, international or transnational soft regulatory tool like United Nations Global Compact. When we look into national contract laws of most of European countries, we see that if we incorporate by reference, we do not need to have the reference clearly stated in the contract, but it can be deduced from the intention of the parties. The contribution of CSDDD here is that it will probably strengthen the understanding of sustainability contractual clauses as binding parts of contracts. Ezgi, please, another slide. Yes. The other attribute that we could tune and change in sustainability contractual clauses to make them more effective is to make the requirements very clear. Suppliers are likely to comply if they know what is expected of them. And here, the standardization and development of the model clauses in supply chains on the European level will be very important. Of course, as I understand, they will still be voluntary, so companies might and might not use them, but they will be a standardization that can be relied on, that companies can turn to and make it clear. And also, it will be easier for suppliers if companies use one standard rather than different clauses in every single contract. Ezgi, another slide, please. Yes, so relational assistance. That's another attribute of sustainability contractual clauses that we should probably focus on if we want to increase their effectiveness. Suppliers need some resources. They need to use some resources to comply with sustainability requirements that are imposed on them. They often do not have these resources, whether we are speaking about knowledge or financial resources. Here, the CSDDD will be interesting again, or coming with an interesting suggestion, and that is that if buyers contract with small and medium enterprises, if the supplier is can be categorized as small or medium enterprise, they should be given a specific assistance with capacity building, maybe with development or changing some management systems. So here the CSDDD comes with a clear suggestion and understanding that we cannot just kind of offload the problem on suppliers. Ezgi, please, another slide. Final attribute that is important for sustainability contractual clauses and their effectiveness is how are these clauses monitored and enforced. I already said that they are not enforced in courts. It's because the contractual remedies as we know them, specific performance damages, they are not really suitable for these clauses where we do not see really non-compliance with those clauses from products that we receive as a buyer. So instead, in practice, this kind of four-step best practice developed using relational monitoring and enforcement. Suppliers are self-assessing themselves, and buyers are conducting audits of suppliers, which is very, very heavy on resources as well on the buyers, and that will be or that is actually interesting aspect in respect to public buyers. And when there is a non-compliance, companies will develop with suppliers corrective action plan, and only if the supplier is not able to comply with this corrective action plan, the contract might be terminated or will be terminated. Here, the CSDDD doesn't come up with anything new, actually. It takes over this best practice that has developed among companies. What will be interesting is again that it will become legalized. It will become a law. So it will not be just best practice, but it will be something required by law. So the legalization effect of CSDDD, I think, is very important here. And the last slide, which I think due to the time, I will not go into detail here. Maybe I will just say that from research that is now already 8 years old, from these 4 attributes, the most problematic one was the clear requirements. The language used in contracts is very vague, and suppliers simply do not know what is expected of them. And if clauses are too vague, they cannot be properly enforced. So it will be very interesting to see how the CSDDD contributes to this practice. And I'm really excited to hear the next speakers.
Great, thank you very much, Kateřina. So thank you very much for setting the scene for us and for the presentations to follow. Now, if I can manage, I will share my own presentation and take you to sustainable public procurement and how we do things on the other side. Okay. So, yes. So Kateřina set the scene for us about the sustainability clauses and how they are used and enforced, which is not traditional contract enforcement, but more and more relational mechanisms. So the more business contracts incorporate social and green and labor-related considerations, public procurement is not indifferent to this trend. In fact, it is one of the Sustainable Development Goals under Goal 12, Responsible Consumption and Production. Target 7 stipulates the use of public procurement to reach more sustainable goals through national policies and priorities. And what about Europe? So how sustainable public procurement works in Europe? Now I will briefly give you the background a bit. This may be repetitive if you already have a public procurement background, but as I mentioned, since this is a hybrid seminar, I will also start with the basics. So public procurement under the EU is regulated through Directive 2014/24 concerning the award of public contracts. These rules regulate how contracting authorities in the EU can buy services, works, and products. On the other side, sustainable public procurement concerns what to buy, what contracting authorities are buying through technical specifications, award criteria, and contract performance conditions, as well as whom they are buying it from through selection criteria and exclusion grounds. Since this legal framework, the Directive 2014/24, mainly regulates how to buy, the questions of what to buy and whom not to buy from or whom to buy from is mainly left to the discretion of the contracting authorities. So the directive as such does not mandate or prohibit sustainable public procurement. However, especially since 2019, following the Green Deal, we see there is a move towards more mandatory green public procurement requirements under contracts that fall under the Public Procurement Directive. So since the legal background, the legal aim is harmonization in the internal market, there is a provision in the directive that regulates principles. So these are principles of equal treatment, principles of non-discrimination, principles of transparency and competition. And amongst these principles, we have another provision which can be considered a principle of sustainability. So under the directive, Article 18.2 provides that member states shall take appropriate measures to ensure that in the performance of public contracts, economic operators comply with obligations in the field of environmental, social, and labor law. Though this is a step forward compared with the previous directive, so 2004 directive, the choices of wording in this provision is quite problematic. To begin with, differently from other principles, it is addressed to member states, and it provides appropriate measures to be taken, but there is no definition or there is no concept of what appropriate measures might mean. It simply refers to the performance of a public contract, so it is not clear immediately whether this concerns the execution phase of a contract, meaning after the contract is awarded, or in a more broad covering the life cycle of the purchase, so including supply chain conditions as well. And lastly, it refers only to applicable obligations, so it refers to law compliance with excluding and the use of public procurement to incorporate positive actions like employment of disadvantage or employment of trainees, such obligations that are going beyond the minimum. But in any case, the cardinal value of this provision has been accepted by the Court of Justice. So like I said, in the Public Procurement Directive, sustainable public procurement, sustainable purchases are mainly discretionary. And this has been the case since the beginning. So the Public Procurement Directive is not necessarily changing, but we also see a change in the whole public procurement legislation through other secondary legislation, especially after the European Green Deal. These are some legislative proposals. Some of them require the adoption of mandatory green public procurement criteria, and there are also some legislative proposals, some of which have been already adopted, like deforestation regulation, which provides that non-compliance with the obligations arising from the secondary legislation can be a reason to exclude. And again, beyond the EU legal framework, there are member states who adopt mandatory green or social requirements. For instance, Italy. In Italy, we have mandatory sectoral environmental criteria, which are required to be incorporated in the contracts awarded. As you might have already guessed, socially responsible public procurement has always been lagging a bit behind in green. And since following the Green Deal, the focus has been mostly on the green. This is again the case, but there are also some new legislative initiatives that focuses on the social aspect of sustainable public procurement. So this is the main scene in sustainable public procurement. What about contracting as such? So regardless of where these obligations arise from, whether it's from technical specification, whether it's an obligation arising from contract performance conditions, these at the end of the day, at the end of the competitive procedure, these make up the sustainability clauses in a public contract. Accordingly, in order to understand how they function, we need to look at them as such. So this takes us to this comparative approach between ordinary contract law, what Kateřina has mentioned, as opposed to public contract law. So in ordinary contract law, there are some limits arising from the contract law itself, because contract law traditionally is not equipped to answer societal challenges. So when we incorporate green or employment-related requirements, the traditional contract law concepts such as non-conformity or fundamental non-performance, these are challenged. And maybe more importantly, contracting authorities, as a result of freedom to contract, they also have freedom not to enforce these obligations in their contractual partners. On the side of public contracting, we have principles of public procurement, like I said, regulating how to buy. We have publication requirements, meaning that all contract documents need to be accessible before the contract is concluded. But the two main difference between the contract law and public procurement contract law that I would like to focus on today is the requirement of link to the subject matter and ban on contract changes. So requirement of link to the subject matter is a requirement developed through Court of Justice case law, specifically for award criteria. So in these cases, it was established that any award criteria or sub-criteria should be required to link to the subject matter. But in time, this concept has evolved and also extended to technical specifications and contract performance conditions. So now under the Public Sector Directive, Public Procurement Directive, award criteria, technical specifications, and contract performance conditions are required to be linked to the subject matter, whereas selection criteria need to be related and proportionate to the subject matter. But what does this link to the subject matter means? So it is quite broad. It covers conditions of supply chain as has been developed through the Dutch coffee case law, but we also have a definition in the directive. So the conditions that relate to work, supplies, or services to be provided under the contract in any respect at any stage of their life cycle, including factors involved in the specific process of production, provision, or trading of those work, supplies, or services, or a specific process for another stage of their life cycle, even where such factors do not form part of their material substance. So again, when we look at this definition, it's quite broad, and the only thing that it excludes is corporate policies. So under these requirements, you cannot legally necessitate for your economic operators to have a specific corporate policy or CSR policy. So when we look at some examples, for instance, requirement for a tender to have no child labor policy would be considered not linked to the subject matter. But if you define what you're buying as shoes not manufactured with child labor, this would be considered linked to the subject matter. Similarly, requiring your contractor to use electric cars in all its business would be considered not linked to the subject matter. However, if you require your contractor to deliver the supplies that you're buying through electric cars, would be considered linked to the subject matter. So though this is the case under the Public Procurement Directive, as I mentioned, we have now an impressive new directive. The relationship between public procurement and corporate sustainability due diligence have been a topic of debate in the past 2 years during this legislative process. There were different suggestions, incorporation of public procurement under exclusion grounds, requiring contracting authorities to carry out their due diligence. But at the final version, we see both exclusion as a provision, but also, and more importantly, maybe for the sustainability clauses, Article 31 requires that obligations arising from corporate sustainability due diligence directive or their voluntary implementation can be used as award criteria or contract performance condition. However, this comes up with a question mark, because if something is to be incorporated under award criteria or contract performance condition, they are required to be linked to the subject matter. On the other side, as the name of the directive suggests, it concerns corporate policies, it concerns corporate sustainability policies. So the question arises how corporate sustainability due diligence can be linked to the subject matter. So I think this is a question that I do not have yet answer to, but I think in the future we will see if for public procurement we will get a more linked to the subject matter adjusted due diligence, or maybe in the next round of revisions for the Public Procurement Directive, we might be saying goodbye to this requirement of link to the subject matter. The last difference that I want to focus on is rules on contract changes. So like I said, Public Procurement Directive regulates how contracts are awarded. Accordingly, in principle, contract performance is not something regulated under the directive. However, one of the exceptions is the rules on contract changes. Because public contracts are awarded through competitive tendering procedures, any type of change to these concluded contracts are in tension with principle of equal treatment. Therefore, unless they fall one of the exceptions listed in the directive, changes to conclude contracts are prohibited. And this does not only cover explicit contract amendments, but also cover waiver of contracting authority to obligation itself in the contract. The same requirement also applies to sustainability clauses. So non-compliance of a contractor with a sustainability obligation arising from the criteria used in awarding the contract, combined with the failure of a contracting authority to enforce compliance, can be considered a waiver of these sustainability clauses. And accordingly, if it does not fall one of the exceptions, it can be considered a contract modification. So this takes us to the conclusion that there is a need for contract management in public procurement contracts as a result of the rules on contract changes. But what does this mean for contract management? It means that public procurement contracts, especially the ones that incorporate sustainability requirements, should be designed in a way allowing contracting parties to follow up and ensure compliance in case of non-compliance with the criteria they are incorporated. However, this does not mean tick box compliance. Rather, the sustainability indicators should be clearly defined, but also should be flexible in the enforcement. So the focus should be on collaboration and progress, and contract termination should be used as a last resort remedy. So when we, to sum up, when we compare this with what Kateřina explained, we reached to similar conclusions. However, differently from private contracting, we come to this conclusion through the ban on contract changes. Thank you very much. Now I leave the floor to Daniel.
Thank you. Will you share my slides as well, or should I?
Yes, of course.
Okay, great. That would be great. That was very interesting from both of you.
Thank you. Yes, there we go.
Okay, perfect. Okay, now I will be focusing on what the CSDDD says about contracts. We have recently, I already put it in the chat, published a policy paper on that from the Responsible Contracting Project. But this is, my presentation only focuses not on the public procurement side, but on the private side of things. But Martijn will add with the perspective on all of this from public procurement. So let's go to the next slide. Just shortly on the Responsible Contracting Project, we are an academic project that is located or linked to the Rutgers Law School in New Jersey. And what we do is we work with companies, with associations, and in projects to essentially, very similarly to what Kateřina explained, try to make it that supply chain contracts actually are an effective tool for human rights due diligence and not just a tick boxing tool. We like our first, so to say, if you want to call it like that, like mother product of our work are the MCCs 2.0, the model contract clauses developed by a working group of the ABA, the American Bar Association, all our clauses are open access. You can access them in the link that you see here. I can also post it in the chat because I think you cannot click on it right now, but later. We developed clauses for the textile sector, textile specific sector, the SMCs. We are currently in the project with Martijn, that Martijn is leading in the process of developing European model contract clauses based on the requirements of the CSDDD and with very many collaborators from different European countries. Yes, so that's basically the responsible contracting project. A lot of people working from the US, lawyers from the US and from Europe. Okay, so let's go to the next slide. What are our basic ideas? We believe, also similar to what Kateřina said, that contracts are very useful for human rights due diligence, can be very useful for human rights due diligence. Basically because they can serve to communicate the requirements and make them enforceable, and they are therefore widely used by many businesses for that purpose. But we like to point out, well, a contract is no silver bullet. You cannot just contract your way out of due diligence. The CSDDD also mentions this in recital 66. So what does that mean? You cannot just believe that, oh, I have a problematic supplier, now I will give them our supplier code of conduct and our contract clauses on human rights, and now everything will be fine. The contract can serve as a foundation, as a framework in which you can collaborate to develop a better human rights performance, but it cannot replace human rights due diligence. And this foundation can be built strongly or it can be built weakly. Our approaches and our model contract clauses aim to build it strongly. What do I mean by that? If you have a contract clause as the next one, we can move one slide. Ezgi. Okay, I didn't put it on that slide yet. Maybe move to the next slide already, and to the next slide, this one. Here, it's good to look at this clause and ask yourselves, like, will this really help human rights performance? So, as you can see, the clause says the supplier undertakes to comply with the requirements on human rights and environmental protection in accordance with section X, and then in section S you will find a list, no child labor, no forced labor, and so on, and to agree corresponding regulations with its suppliers. If the supplier either violates the aforementioned obligations, violates an obligation under the German Supply Chain Act, or if a human rights or environmental risk arises, company X, the buyer, is entitled to terminate the contract without notice. This is a clause. Clauses like this are being used in German practice right now to comply with the German Supply Chain Act. If you see a clause like this, you should ask yourself, does that help human rights? We believe that this clause essentially does not help human rights, because the problem of this clause is it's very one-sided. Only the supplier has obligations, while the buyer has a role to play, as Ezgi and Kateřina both mentioned. The buyer has to collaborate. This is not a thing you can just load off to your supplier and the buyer doesn't have to change anything. The buyer doesn't have to offer technical assistance when problems arise, and the supplier doesn't understand what the human rights requirements and problems and possible solutions are. Also, the buyer has to look at his own behavior. If the buyer is pricing very, very lowly, or if the buyer, for example, does last-minute order changes or last-minute orders, it's very hard for the supplier to have production in line with requirements on fair wages and on fair working times, for example. And lastly, if you have such a strict termination right, like here, and like is unfortunately still quite common in several contracts, terminating at any problem that arises, any risks or violations without notice, you have a very strong incentive to hide problems. Because if you say there is a problem, well, you have the risk, you have the sword of Damocles above your head as a supplier, that the contract may be terminated. And this is a problem because risks and violations occur in any company or in any supply chain. For example, in the German Supply Chain Act and in the CSDDD, it is mandated that discriminations have to be avoided. So in any company, in any larger company, workers, employees, discrimination will happen because our societies are still prone to a certain level of discrimination of women or because of racism. So it's very unrealistic to say that your operation will be managed without any human rights risks or violations. And this creates the incentive to hide the problems, to not openly answer, for example, questionnaires of self-assessment, to not talk about problems when the buyer asks the supplier to talk about his human rights policies, about his human rights risks, as is common, and in order also to try to paint a very positive picture. So we believe, and this is kind of our fundamental understanding, that these kinds of clauses do not really help human rights. And we want to offer, with our tools and our principles, other solutions. If you want to move on to the next slide, Ezgi, there I could. So in this, we are also supported kind of by the CSDDD in our reasoning. Our reasoning was there already before the CSDDD, but I will focus on what the CSDDD says to support this reasoning. So you can look at the rules of the CSDDD on appropriateness and effectiveness. All measures have to be appropriate and effective. And this means, yeah, maybe it's useful if we go to the slides that I omitted 2 slides before on that point. Yeah, sorry, the next one with the appropriateness criteria. You have to have appropriate due diligence measures in the CSDDD, and this means that these measures have to be designed to be effective, to actually offer some improvement for human rights. The next slide is the one explaining appropriateness. Sorry, yes. And they also have to reflect the potential joint causes that both companies, that means the buyer and the supplier, have created for the human rights risks and violations that need to be addressed. And they also have to reflect that the solutions that companies find have to be reasonable, available, and have to reflect the likelihood of impacts. So these are the criteria that you can read in Article 3.0 and in Article 10 of the CSDDD. And these criteria create a lot of consequences for the use of contracts. On one hand, the one-sided obligation for a supplier that we just saw in the example clause is problematic because it doesn't reflect the need that measures need to take account of the joint causes of impacts. So if you have a contract where you say every risk and violation that occurs at the supplier level is always the responsibility of the supplier, you ignore that the CSDDD says that the buyer has to engage in responsible purchasing and that the buyer has to avoid creating contributions, creating joint causes for human rights risks and violations. So these kinds of clauses from the outset ignore the requirement that they have to be designed to take this situation into account. They create a legal fiction that deviates from reality and deviates from the CSDDD and this understanding of shared responsibility. And the CSDDD's legislator seems to share this interpretation. If you look at the recitals which can be used to interpret the text, they clearly say that contracts should reflect the shared responsibilities of both parties, and that they should clearly and reasonably allocate the tasks between the parties. So it's not only the contract creates tasks and responsibilities for the supplier, but the contract should also reflect the buyer's responsibilities, in our view of responsible purchasing and of collaboration. Then, if you can move on a slide, you have the next problem that we saw in this clause, and that is unfortunately also kind of widespread, the obligations of perfections, no risks and violations. They are ineffective in our view. Why? Because they create harmful incentives. As I explained, if you have such an obligation, you will be scared to be sanctioned, and then you will want to hide problems instead of addressing them, and instead of being honest in questionnaires, in audits, in interviews with your buyer. They are also out of line with the appropriateness criteria that I just mentioned, because being perfect is not reasonably available to any company, and it also doesn't reflect the likeliness of impacts occurring in reality in every supply chain and in every company. Instead of this, the CSDDD also mentions in the recitals some useful aspects that can be used to think about what the CSDDD wants instead of that. So in recital 46 and 45, you will see the requirement of shared responsibility to human rights due diligence. But more importantly, in 66, you will see that the idea of the contract clauses that the European Commission wants to develop should be based on ongoing cooperation. So the contracts should create a room in which the parties will together improve the situation. This means that saying if anything occurs that's a breach of contract from the outset is not really what the CSDDD is looking for. It is looking for when these risks and violations occur that the parties address them jointly. For example, as Kateřina said, with corrective action plans, and only if that fails as a last resort could there be room for termination. If we can move on for an example, how we frame these kind of obligations or how we formulate them in the EMCs. I brought you our human rights compliance clause. So this is the first, I think that's Article 1.1 of the EMCs. We address their human rights obligations like this. Buyer and supplier each covenants to establish a HREDD process in connection with the goods and services governed by this agreement. That's the first part. You can see shared responsibility to human rights due diligence. Why to human rights due diligence? Because human rights due diligence is exactly this process, not the process to be perfect, not the obligation to be perfect from the outset, but the obligation to identify problems, prioritize them, and continuously improve. The same standard of obligations of means that the legislator formulates for the companies should apply for the suppliers. And then we continue essentially with the clause here. If the supplier is an SME, the supplier can opt to establish its own human rights due diligence process or to be involved in the buyer's process. Why did we formulate it like this? The first reason was we said SMEs, you should not oblige an SME always to do its own human rights due diligence process, because this is a very complex thing to do. It would be different if there would already be a very good standard of human rights due diligence with SMEs, which recognizes their limited capacity. This standard doesn't exist in our view yet. If anyone opines differently, I'm very interested to learn more about it. But the standards that I know about SMEs right now that have been formulated are still not sufficiently tailored to their reality, I believe. So we say the SME should only participate in the human rights due diligence process. What does that mean more concretely? For example, in the risk analysis, the buyer has the responsibility to look at the product of the SME that he is buying from them and say, okay, these are the typical risks of this product. Please, supplier, SME supplier, let's have a talk about what you are doing to address them. Yeah, but the initiative lies with the supplier, with the buyer, sorry. The SME supplier has to collaborate. Of course, that's necessary for successful human rights due diligence. Similarly, in the grievance mechanism, the buyer should set up a grievance mechanism, and then the SME supplier should make it available at its location. The SME supplier does not have to set up an own complex grievance mechanism focused on human rights. But as there are some SMEs that do want to do their own human rights due diligence processes, we added another phrase. We added the phrase that the supplier can also opt to do his own human rights due diligence process. He doesn't have to participate. If he says, we are doing our own human rights due diligence already, he does not have to be integrated full scale in the human rights due diligence of the buyer. He can, for example, say, we do our own risk analysis. Of course, we share it with you. We have our own grievance mechanism. Of course, we explain it to you. And if you say it's insufficient, we are, of course, ready to make it better, but we do our own things. Okay. And then on the last slide that I want to present to you, there are some things that the CSDDD also rules out and rules in on the question of who does what in human rights due diligence and on termination. So recital 66 points out that transferring all obligations to the suppliers is not what you should do with your contracts. The recital 66 does not explain this in detail, but we believe this is very reasonable, can be derived from the questions of capacities and also of the buyer's own role. If you transfer all obligations to the supplier, it's very likely that he will not be reasonably equipped to fulfill all these obligations. And it's also likely that this will ignore, again, the joint causes that the buyer creates. So it's out of line with appropriateness and effectiveness. Instead of this, companies should create room for cooperation and collaboration on human rights due diligence that allows the suppliers and especially SMEs to participate in this process. And they should establish forms of cost sharing that reflect when a buyer contributes to a human rights harm. You cannot just offload all the costs to your suppliers. You can also not reasonably be expected to co-finance everything, but where you contributed, where you had a joint cost, for example, because you did irresponsible purchasing, you did not take into account, you only selected via price and quality and did not take sustainability performance into account at all. You procured from low wage sectors and still did not look at fair prices. So these could be contributions to problems that then arise that should lead to cost sharing. Lastly, immediate termination is a problem under the CSDDD because it creates not only the risk of not addressing human rights issues because the supplier will hide problems if he always has to face this risk of the immediate termination, but also because termination is problematic for human rights because workers might lose their jobs. For example, if you terminate with a child labor issue, it might just be that the child will work in another place and be exploited, will still be exploited. So instead of this, you should have a system of responsible exit that gives the suppliers first the right to cure. Yeah, first say, okay, this is the problem. This is the measures you should take, the corrective action plan. Okay, you don't collaborate in this. You're not ready to collaborate in this. Okay, that is a situation in which we might terminate. But if you do engage with the problem and do fulfill the corrective action plan, then you should generally not terminate. There might be some room in very exceptional cases for immediate termination still. There have been cases in Germany, like, for example, in the trucking sector, of a certain trucking supplier that attacked his own workers with paramilitary forces. So this kind of issue could show from the outset that this supplier is not really ready to work with you on human rights. In these cases, it might be because there's no reasonable expectation for change feasible to terminate from the outset, but that's the clear exception. So that's it from my side on CSDDD and contracts. Thanks a lot.
Okay, great. Many thanks, Daniel. I think this brought together from Katerina's and my presentation's main topics, but also from a more practical perspective, because at least in my research, I encounter the similar perspectives going from all or nothing compliance to more shared responsibility and collaborations. And I think EMCs are doing a great job representing these from a very practical perspective, like ready to be adopted clauses. So thank you very much. Now I am giving the floor to our last speaker.
Thank you, Ezgi, and well, it's a pleasure to be here. Ah, excellent. You're also presenting my sheets now. Next sheet, please. Okay. Well, this sheet depicts the obligations from the CSDDD, but it does so using the due diligence cycle from the OECD guidelines for multinational enterprises, which include 6 steps. And what I have done is kind of connect the articles in the CSDDD to the steps of due diligence. And so Article 5 is the kind of foundational article which explains that you have to implement due diligence. And then the first step in Article 7 is that you have to embed or develop a policy, but also embed responsible business conduct in your management. And so, for example, train people, but also means commitment within the whole company, not only with a specific department on sustainability. The next step is to identify and assess adverse impacts, and not only in the own operations of the company, but beyond that. So it's well, that's limited in the CSDDD to the supply chains, or basically to supply chains. But it's much broader than just the own operations. And when adverse impact has been identified, then companies, at least if they cause or jointly cause such impact, have to provide or cooperate in remediation. Well, you see the articles mentioned where that's said. Of course, if potential or actual adverse impact is identified, then a company has to act. So Article 10 relates to a potential impact and then says that companies have to prevent, of course, preferably, or, well, if that's not possible, try to mitigate the potential impact. Article 11 relates to actual impact. So then, well, it's about trying to seize or mitigate the impact. And Daniel already discussed Article 18, which explains that the European Commission will provide guidance on model contracts. Obviously, after that, companies have to check whether their measures are effective. So that's Article 15, monitoring, and also have to communicate not only about their more general, in a more general sense, about their policy, but also on specific impacts. And for many European companies, that's already embedded in the Corporate Sustainability Reporting Directive. So that's another one next to the CSDDD. But for other companies not governed by the CSRD, that's Article 16 of the CSDDD. So that's basically the due diligence cycle as embedded in the CSDDD. And it is a cycle to show that it is not a one-off thing you do once, but it is a continuous process. So it is a thing which companies have to do continuously, and it should also feed in. For example, if you have identified impact, it should feed in their policy. So it's also a continuous learning process. Okay, next slide, please. Ezgi, could you present the next slide?
I'm changing, but
It is now stuck.
okay, let me just stop and reshare it. Sorry about that.
No problem.
Can you see it now?
Not yet. It states that you are now starting to share
I
content.
can see it. I think that it might be the problem might be on your computer. I saw the Amsterdam slide, if that's the next slide.
Yeah, exactly. Or should I try to?
Yeah, maybe if
Sure.
I can give you the presenter's view. I don't know
Trying to
why this
share my,
happened.
yeah. Okay. Can you see it now? Or?
Wait.
Start it. So, but do you see it or not?
Yes, I can see it.
Yeah, I can see it. Okay. So then we'll go to the slide, which is indeed about Amsterdam, but it is in Dutch, so probably not digestible for the most of you. But it is about surveillance cameras in Amsterdam, the municipality of Amsterdam. And it states that now in its public procurement, the municipality of Amsterdam is mainly abolishing Chinese cameras because of, well, cybersecurity and human rights related reasons. And so they are well, replacing those cameras with other cameras. And of course, this triggers a public procurement phase. And well, the interesting thing is I have been involved in a project for the Association of Dutch Municipalities, which has developed a framework to do exactly this. So a framework for sourcing surveillance cameras and then having selection and award criteria focusing on cybersecurity and human rights related topics. And on top of that, they also have developed contractual clauses to be used in procurement contracts to implement this in the contract stage. On top of that, and that is also interesting, I think, more broadly than in just the procurement of surveillance cameras, is that, well, we have also developed a more general human rights clause, which can be used in procurement contracts. So this is an interesting start of well, actual implementation in practice of these clauses. And well, I think Ezgi already alluded to that. Of course, recital 92 of the CSDDD also states that the member states have to see to it that compliance with the CSDDD can be used as award criterion in procurement and contracts. And of course, it can be connected to compliance with national laws, of course, because this will be transposed in national laws. But also beyond that, I think it is also relevant as a sustainability feature. So it's also important that it says that the contracting authorities, contracting entities may be required by the member states to use this in there as a requirement for participation in the procurement procedure. And so where of course there's a problem in terms of violations, for example, well, that can be a thing, and I will come back to that later, which can be used. So to a certain extent, it can be used as a selection criterion, and not only as a award criterion. So it's, well, from that perspective, I think also for business, this becomes more and more well, salient in terms of well, the necessity to implement proper due diligence in their practices. And the last thing, which is the recital also refers to is that it states that the European Commission shall also consider whether it's necessary to update the procurement directive, especially sustainability regarding sustainability due diligence in terms of, well, exploring whether the current directive indeed allows implementation of sustainability related selection and award criteria to the extent that necessary to implement due diligence. So from that perspective, I think this is a very helpful recital. And of course, you already mentioned that as well as the Article 31, which indeed said that the member states should see to it that as part of the award criteria, these requirements may be laid down in connection with public procurement. And so that it should be guaranteed, or at least governments can see to it, and contracting authorities can ask for compliance with the CSDDD. And of course, that would only govern very large companies, because as you all probably will know, is that the CSDDD will only govern very, very large companies in the end after 5 years of 1,000 employees or more and 450 million turnover on an annual basis. So those are the very large companies. But I think, of course, governments will probably seek to implement these requirements beyond application of the CSDDD, and also in public procurement where much smaller companies are involved. An interesting thing is that in the Netherlands, we have already seen the first examples of exclusion of companies because they provided incorrect statements about their sustainability performance. So, for example, in one of the public procurements, the contracting authority asked for a specific EcoVadis score to be selected in the public procurement. And, well, this company stated that it indeed met the requirement, but apparently wrongly so. So it was not actually meeting the EcoVadis score. So then it was excluded from the public procurement, of course, litigated in court, trying to fight this exclusion, but well, that did not, but unsuccessfully. So the court affirmed that indeed the exclusion of this company was justified. And so, well, using that as a selection criterion, so I would, for example, also imagine that compliance with the CSDDD, if a company would be governed by, well, and other types of such sustainability attributes can, well, to a certain extent also be used as selection criteria. Of course, it has to be proportional, but well, I think that will really show that this thing is increasingly becoming important. Though what I see in practice is that implementation of such criteria, well, selection maybe less so than the award criteria, and especially also then consecutive contractual requirements on human rights are quite challenging still. We see not much expertise with this by contracting authorities, because, well, many of them are not so familiar with well, these types of due diligence. Another problem is that, of course, well, they can ask for these due diligence requirements, but on the other hand, of course, there may be some cost involved, and so, well, then the price may be different when vis-a-vis situations where you do not ask for this. So if there's a lot of pressure on price, well, then yeah, it will be hard to implement, or either hard to implement it, or well, in the terms of the scores of the companies which participate in the public procurement, well, then it will not be very important. So and some fear also with contracting authorities that if you have too harsh requirements on sustainability and especially human rights due diligence related requirements, that then no company will indeed effectively engage. And so there will be a problem in terms of getting things done. But I do see these days that more and more contracting authorities are now confident that, well, these type of criteria will not mean that nobody engages, because they become more part of the legislative landscape as such. So at that point, I think things are changing now. But still, we see a lot of grappling with these clauses in terms of expertise with due diligence. Many public procure or contracting authorities don't have that type of expertise, so it's for them quite hard to implement it, but even more so to monitor what is happening. So sometimes there are contractual requirements in place, but then for the contracting authorities to check and monitor what the company is actually doing and whether things actually go wrong in for example, global south countries, well, that's very hard. So usually we do not see any monitoring happening, and that I think is a big problem. But it is not so easy to find a solution for that, because you cannot expect, for example, a smaller municipality to start checking around the world what is happening. So it's not so easy to find a solution for that. But an interesting example we had in the Netherlands was, or it still is because it's still existing, the International Responsible Business Conduct Agreement regarding natural stone. And of course, you probably know that in the natural stone quarries in many global south countries, there are big issues in connection with forced labor, excessive overtime, child labor, other types of human rights related violations. And so the aim of this International Responsible Business Conduct Agreement, amongst others, was to address these type of human rights violations. And this International Responsible Business Conduct Agreement is a tripartite agreement between the government, businesses, and NGOs on the implementation of the OECD guidelines in the natural stone sectors. And in this agreement, of course, well, business and the NGOs discuss what business should do in connection with these issues in the natural stone sectors. But then also they turn to the governments, and by the way, that was not only the Dutch government, but also the Belgian government, and said, well, we feel that then, of course, in public procurement, you should also well, think of these issues and implement requirements, award criteria, for example, to address these issues and check what is happening. And that was quite challenging both ways, because monitoring ASADA for smaller municipalities, that's challenging, but also because many businesses were smaller businesses and did not have that much leverage to well, exercise pressure on, for example, global south quarries to indeed change well, their practices. So two things happened. The company started collaborating on these issues, so trying to collaboratively try to develop a leverage, and also engage with NGOs to monitor, also using local grievance mechanisms to see what's happening in practice. So that also supported the well, monitoring by the government. So I think that's an interesting model where, well, the collaboration between business and also with the NGO using grievance mechanisms assisted also the governments in checking whether, well, there is actual compliance with their norms. Of course, at that time, because this, I think the pilot has been conducted like 4 years ago or so it's a little bit older already. The contractual clauses used in that exercise were not commensurate with the CSDDD. And of course not with the European model clauses as well. But what now has happened also in the exercise I just mentioned on the surveillance cameras, I said we also developed a clause which is now commensurate with the CSDDD and the EMCs to be used in public procurement. So it's a more general human rights clause. So not only for surveillance cameras. And one of the important things of that clause is that it is building on collaboration and not, as is usually done in procurement contracts, a human rights impact as a default event. So the impact as such is not seen as an event of default, will not trigger termination rights, but triggers a collaborative approach where, well, then parties start to negotiate or at least discuss, well, how this problem should be solved. And so the supplier has to then develop a remediation plan, discuss that with the contracting authority. So it's a little bit more of a collaborative approach, which is also implemented in the EMCs. Well, of course, there are some interesting features in terms of the responsible purchasing practices, which are also implemented in the EMCs, where, for example, buyer and supplier agree to collaborate on prices which accommodate a living wage, for example. Well, that I think is, we then think of contracting authorities, same thing I think would be very relevant to the contracting authorities as well. So if they have a pricing kind of policy which would not allow this, well, then of course you cannot expect the supplier in its chain to implement it as well. So those are things which are very important, I think, for the contracting authorities as well. And then another feature of the and also already discussed by Daniel is the responsible exit clause. There, of course, I think it's also for contracting authorities very important to realize that a supplier cannot always just terminate contracts in its supply chain because of this requirement. And so that's why in the model clause, which is at the Dutch procurement website, that's a state kind of administered website, which all kind of has all kind of information on public procurement, but also this human rights clause. And that's also why the clause as such does not allow immediate termination when a human rights impact occurs, because it's not seen as an event of default as such. So that I think also relates to this responsible exit, so that then the contracting authority cannot just ask for or then terminate if such things occur. So that, there I think we have a nice translation of transposition of the CSDDD EMCs also in contracting practices. I'm afraid I have been talking too long already, so I will stop here. Thank you very much.
Thank you very much. I think this has been a very nice conclusion to all of the previous presentations, combining corporate sustainability due diligence, public procurement, as well as more national approaches, how things are being done in the Netherlands. Now we still have 2 minutes for questions, and we have 2 questions already. So I think we can just start with those. So the first one was from Raquel. She asked, do you believe that environmental policies are able to bring public contracts some social outcomes? I think yes, but in my opinion, that this comes in 2 separate levels. First is that in the broader scope of green public procurement, there are already some social aspects. So for instance, like I give the example of Italy. So in Italy, there are mandatory environmental criteria that are required to be incorporated in all of the contracts awarded. And some of these green criteria already have employment or labor related obligations within themselves, even though the name is green. So I think this is one of the layers where social is combined with environmental under sustainability in general, but also, as I mentioned, enforcement of sustainable public procurement once the contract is awarded focuses a lot on contract management, which, as Raquel also mentioned, it goes a lot to planning. So you have to plan the contract in order to be able to enforce. And I think this requires a capacity and professionalization in public procurement professionals. And if even we start doing this with environmental policies, I think this professionalization and capacity building will also help in the future for use of social or responsible public procurement as well. So I think, yes, I do believe environmental policies will be bringing also social outcomes. There is another question to Martijn, if you can see it, or I can read it. Requiring a certain type of EcoVadis score to participate in the tender is not considered as a criterion that limits competition. Was equivalence with other types of attestation or certification foreseen?
No, very good question, I think, and of course, well, in this court case, of course, many of these issues have been discussed. And well, in the time I have, I'm afraid I cannot extensively discuss them all. But at least the court found that was not a problem in this case. So that indeed also competition law did not preclude the contracting authority to use this type of selection criteria. So yeah, apparently, well, it was this well, using this EcoVadis score was allowed, also bearing in mind competition law.
Okay, so another question, do you see a difference in the requirements set in frame agreements versus single case agreements? Would you like to comment on that? Either one of you? I think from a public procurement perspective, the use of aggregated purchases like framework agreements may be providing us the necessary gateway in forming a collaborative framework in public procurement, because the problem with public contracts is that because of the principles or because of the legislative framework, you have to tender each contract. So it is not legally possible as much as the business contract to establish long-term businesses. But when you tender for framework agreements and then contracts to be awarded under framework agreements, I see there is more potential for collaboration and for long-time value creation. I don't know if you would agree for that for the business contracting as well.
Yeah, no, I think, of course, that's mainly where also the EMCs are a little bit steering on, that you indeed build longer lasting relationships and not the hit and run strategies that we have seen in the past. So indeed, and the idea is that, well, building such a longer lasting strategy that also helps in terms of support, better understanding of the expectations both parties have. Indeed, that types of contracting may be much more beneficial in terms of really implementing due diligence than indeed very short-term relationships. Yeah.
Yeah, I would agree, but I would say, like, I mean, it also depends on how the framework agreement is designed. Like, kind of, if it gives the buyer the option to very short notice say, oh, like the supplier has to stand ready. The buyer can say, next week I want product X or service XYZ. They can still be a problem.
Okay, and one last question. How labor obligations may become social factors when they're already mandatory. So I think the difference being mandatory labor conditions to be also public procurement criteria is that, yes, even when they're not included in the contract, there is an obligation incumbent on the successful tender to comply with labor obligations, or now with the corporate sustainability due diligence obligations. But when they are incorporated in the contract as a social criteria, whether this is a selection criteria or whether this is a contract performance, this gives contracting authorities to place to oversee and have a control over these obligations. So yes, there is an obligation to pay minimum wage to the when you provide cleaning services, the employee should be paid minimum wage required by the collective agreement. But when you put these obligations in the contract, it becomes an obligation to be enforced by the contracting authority. And as we see from the minimum wage cases concerning public procurement, this gives the contracting authority an enforcement mechanism it would otherwise lack. So I think this is where the difference comes from. Yes, this is already a law applicable, but when you put it in the contract, you contractualize it and provide a mechanism for contracting parties to have a say on this, I think.
Yeah, I would agree. And I mean, the other thing is, if you think about tier 1 and tier N, the one thing is like tier 1, if you think about tier 1 in Europe, it might be that all the standards, all the social standards in the CSDDD are already national law. But this might not be the case in the deeper supply chain, and you have the interest to engage with the deeper supply chain via the tier 1 supplier if you want to uphold human rights due diligence. And you need the thing that Ezgi describes, like you need the leverage over your tier 1 suppliers to react to these kinds of violations, even if they are already a legal obligation for the supplier. But if you are an entity that wants to do human rights due diligence, you need the leverage. You need to have the hook.
Yes, so thank you very much for everyone attending and to our presenters for this very engaging conversation. I would look forward to collaborating more in the future, as I'm recently discovering that we have a lot of work in common. And once again, many thanks for your contribution. And have a nice day and have a nice weekend.
Yes, and we
Thank
should
you very much.
We should definitely continue this conversation
Yes.
and look
think
at
so.
all the problems more in detail. Great.
It was
Thanks.
a pleasure. Thank you.
Bye. Bye.